that's not the remit of the Election Commission. The Election Commission could not have assumed jurisdiction. So you assume jurisdiction where you don't have it. Well, this is most unfair, Madhus. That's why, Madhus, institutions ultimately, if they don't inspire confidence, this is what happens. The party would contest the by-election. So this was a dispute between two factions, two rival factions in the party. So the very assumption of jurisdiction is wrong. And then, Malaj, our symbol is taken away. Everything is taken away. A new government is formed, entirely according to me illegal, but then that's an old story. Nothing can be done about it.
CEC, for symbols, is a different
No, with this.
overlap of facts. But the questions which the tribunal need to answer are different. Like when you see the disqualification.
No, more, Malaj, more. More, not just that much. Passing of a resolution, appointing their own person as the whip.
When you see disqualification, facts, subsequent facts are not to be taken into consideration.
Malaj, this court has now held that it is illegal. Malaj, that finding is already there. 16 people, against 16 people, we move on the 23rd. The balance people we moved on 22nd of July. So it's not just those two facts, Malaj.
Symbols order, because the disqualification really, apart from maybe if you ask us that the findings are correct or not, really it will not have any impact on the decision.
No, but the speaker has decided against us. So he couldn't have, Malaj, we are in appeal against that order. Yes, Malaj, we are in appeal against that order.
It's infructuous because the decision.
No, Malaj, I'm sorry. This will always stand in the way as a judicial decision. We are in appeal against that order.
Order of disqualification, either by the speaker or when it is upheld by your lordships, relates back, my lord, to the date on which the prohibited conduct occurs. Right, my lord? Now, my lords, the decision, whatever your lordships will render in the disqualification case, has a direct impact on my symbol dispute.
Mr. Shinde, even if disqualified from the legislative party, continues to be a member.
No difficulty, my lord. But the problem is the election commission in deciding the symbol says that he is a majority of the legislators. And therefore, my lord,
that's the point.
That's the only point on which the election commission has given the symbol.
At point.
So Malaj, the point I was making was these three judgments, which he cites, on the basis of which he assumes jurisdiction, he could not have assumed jurisdiction under paragraph 15. Because he assumes it on the basis that because there's a split in the legislative party, it's a split in the political party. Ex facie, that's wrong. If he can't assume jurisdiction, then on what basis did he move forward?
That is not the only reasoning given. That's of course you are right. One of the reasoning given is like this.
That's the only reason, Madhu. Thereafter, he says the legislative party, they had all the membership. Organizational election, I won't look at. I've given you those reasons. I won't look at the 2018 constitution. I don't look at the 2013. It's not on my record. I will not bother about that. Legislative majority, so symbol goes to him. That's the logic, Mullah.
So reasons are there. Those may be good or bad.
No, but that's no reason. That's no reason. This is a very, what should I say, very well-crafted reason. It's a part of craft. I was, yes, we were at 17th of February. I was reading that date, Malas. We'll do it.
Point number 34.
When we do the propositions, we'll do that. Now, Malas, Election Commission has erroneously refused to place reliance on the support enjoyed by the petitioner amongst the majority of the apex organizational body of the Shiv Sena, namely Rashtriya Karyakarani, only on the ground that it represents a small counting universe of para 13.
13 members.
Of 13 members. That's para 107 at page 509. From 509 of the convenience compilation. That's all right. I'll do that. Be that as it may, the Rashtriya Karyakarani is being referred to by the petitioner and the respondent as the apex body with the numerical universe of 13. As mentioned above, the Rashtriya Karyakarani is a body which is elected by the Pratinidhi Sabha, which itself is a largely appointed body. Further, The 2018 constitution of the party states that the strength of Rashtriya Karyakarni shall be 13 members. Lordship has that? However, as per the letter of 27/2/2018, by way of which details of the last organizational elections were communicated, names of 9 elected Shiv Sena leaders were mentioned and details of the other 4 positions in the Rashtriya Karyakarni were not mentioned therein, which is completely wrong, Malaj. I'll show that to your Lordship on the record. 4 Shiv Sena leaders were appointed by the Shiv Sena Paksh Pramukh, who are required to be elected by the Pratinidhi Sabha during the next organizational elections to become members of the Rashtriya Karyakarni as mentioned in the party constitution. The credibility of the numerical count in the Rashtriya Karyakarni is being eroded by the smallness of the counting universe being 13. It also is being denuded by an opaqueness in the description of its membership and it being situated in a non-democratic system. So where is the jurisdiction for the commission to do that? And the commission now refers to the 2018 constitution, which the commission discards. Then let us come to C in the list of dates. The Election Commission has erroneously refused to place reliance on the majority by the petitioner in the main electoral college of the party, namely Pratinidhi Sabha, on the ground that it is largely an appointed body. The Honorable Election Commission has disregarded the organizational wing of the Shiv Sena political party on the erroneous basis that the same is not in accordance with the 1999 party constitution and that the same is undemocratic. But where is the question of this in a para 15 dispute? It is respectfully submitted that the Election Commission had no jurisdiction in proceedings under para 15 of the SIBAL'S order to disregard the organizational leadership of the party, which had been duly notified to and taken on record by the Election Commission. Reliance is placed on the law laid down in Chotubai Amar Singh Wasawa versus Nitish Kumar, where the Election Commission held that organizational elections of a political party or the non-compliance with the party constitution cannot be agitated in proceedings under paragraph 15 of the SIBAL'S order. Similarly, in Arjun Singh versus President Indian National Congress, Election Commission held that in proceedings under 15, it is not open for a party to allege violation of the party constitution when both sides have acquiesced and acted in the same breath. So both of us never went to the commission, Madhas. Where did the commission get this from? The Election Commission has failed to appreciate that the members of the Legislative Assembly are elected to the House on the ticket of the political party based on the prescribed form furnished to the returning officers by the authorized political leadership of the party, which is the SIBAL'S order.
Rest of the board is discharged, no other case will be taken.
Thus, the organizational wing of the political party is the basis on which a candidate is able to contest the election as a member of the political party. And even after election, his name is recorded along with the political party to which he belongs. To disregard the organizational wing is being based on an undemocratic constitution and instead rely upon the legislative wing, which owes its origin to the very organizational wing, is completely absurd and unlawful. Despite finding that both parties had relied on the 2018 constitution, and despite the same being duly supplied to the commission held that the same was not categorically taken on record. Malas, where is it in the section 29A? Where is it that an amended constitution has to be taken on record? We must inform the commission of the amendments. The only constitution that is taken on record is at the time of registration, because the guidelines to the commission say that you will have to, in that constitution, have a provision for amendment of the constitution. So, as and when we amend provisions, we inform the commission of what is amended. That's all. Though it is our case that we gave it along with the letter, but we can't now prove any of that. They deny it. But the fact of the matter is, where is that requirement? Moreover, the Election Commission erroneously held that the 2018 Constitution was not democratic. Based on these untenable reasons, the Commission has based its entire decision-making process on the legislative majority employed by the respondent. See the Malad, see the... No, but see, Malad, the unjustness of this kind of a analysis. The Speaker doesn't decide the disqualification. The facts are clear. They are covered by a judgment of the court. They are covered by several judgments of the court. You don't decide it. The Election Commission disregards the organizational wing, decides on legislative majority, which should not have ever happened, that government should never have been formed because they were deemed to be disqualified. And then, Mullah, the whole process takes place, and then they get everything, the party, the symbol, and Mullah, these people in power are like a magnet, Mullah, as your lordship knows. That magnet attracts a lot of disparate people, even disgruntled people or happy people, because they look for new prospects. So your 31 will become 39 and 39 will become 56. And if you let that happen, which is, I think it was, according to me, and we will in another case argue, this is a wrong procedure to adopt. To let the disqualification linger, hopefully in another case I'll argue that. So, Malas, now 22 to 2023. Amalas, at the time when the split took place, they had 20 members, 1 member of the Lok Sabha. We had 21 members of the Lok Sabha who were with us. 18 Lok Sabha and 3 Rajya Sabha who were with us. They all went away after he became Chief Minister. It was bound to happen. So it's this creeping majority that takes over because power attracts. Anyway, the petitioner filed SLP number so-and-so against the final order dated 17/2/23 and 20/2/23. Notice was issued in the SLP and interim directions were passed by the commission, by the court, continuing the name Shiv Sena, Uddhav Balasaheb Thackeray and the symbol. Flaming torch allotted to the petitioner group by the interim order dated so-and-so passed by the commission. The Constitution bench of then Malas, we come to Subhash Desai's judgment. And kindly see, Malas. Political party and the kindly look at Malas, Subhash Desai's judgment. You will find that at the compilation.
No, there is no one. I'll keep telling you the page.
Okay.
It was like-
I just give it to Malas.
I can show it to you.
Yeah.
Six. He doesn't have the new one. I'll keep telling the page numbers of the new one. Yes, telling.
That I'll tell.
ठीक है.
What the original judgments volume was too thick, Malas, 400 odd. We don't need that. So we've sort of made a smaller volume for your Lord.
Also stop going.
It's easier this way, Malas.
All the 11th ones are there.
Yes, all the relevant judgments. So if you look at Malas, Subhash Desai straight away, which para? Para 109, page 71.
Political distinguishing of classes.
Yeah.
Read the heading and then the conclusion from your own.
Yeah, so which page is that? Whereas if your lordship looks at para 104,
Page 69.
page 69 for a minute.
Just the heading.
Just the heading, Malas. Just above para 104, the heading is political party and legislature party are distinguishable concepts. Lordship has that? Then you come to para 109. That's at page.
Paragraph is given.
But first paragraph 104, just above that, Malas, at page 69, just the heading of paragraph above paragraph.
The power to
Political party and legislative party are distinguishable concepts. That's where the learned judges discuss, Malas, this issue. And come to 109 then. Bottom of page 71, last paragraph. Political party and legislature party cannot be conflated. The contention of the respondents that political party and legislative party is inextricably intertwined is erroneous for the following reasons. So they reject that argument. Parliament in its constituent capacity was conscious of the necessity of not allowing anti-defection laws to stifle intra-party dissent and the freedom of expression of legislatures. It was with this objective that the defenses of merger and split, which was later omitted, were introduced. The 10th schedule confers legitimacy to the actions of the legislatures, which would otherwise lead to disqualification if a substantial number of legislators, 2/3 in the case of a merger and 1/3 in the case of the erstwhile provision for a split, disagree with the political party. The 10th schedule recognized the independent exercise of the legislature party to the limited extent of presenting a defense to the actions of the legislators, which would otherwise have amounted to defection. Kindly see. Because the whole purpose of both paragraph 3, which is now erstwhile, and 4 is as a defense. So if I seek disqualification, the defense can be in a situation of a split under paragraph 3 that I am 1/3. In paragraph 4, that I am merged. The political party has merged and 2/3 of the legislative party has agreed to the merger. As a defense. But you can't interpret it. I'm sorry. Section 29A of the Representation of People's Act requires an association of individuals calling itself a political party to be registered with the ECI. The party need not have returned candidates to the assembly to be registered as a political party. Under the symbols order, a political party receives recognition as a state party or a national party based on the total number of candidates returned to the assembly by the political party and or the total percentage of votes secured in the election. The purpose of the requirement on the symbols order is to identify whether the political party has a substantial presence in the electoral fray to freeze an electoral symbol for that party. The symbols order does not refer to an association of legislators, dehors the political parties. Like the 10th schedule, it recognizes a legislator and a political party. Thus, the reference to provisions of the symbols order to argue that the concepts of political party and legislative party are intertwined does not hold merit because the concept of legislative party is not recognized by the symbols order. This is very important. It's only the political party which is recognized.
The primary substratum political.
That's right.
From that springs the legislative.
Absolutely. And if you base your decision on the legislative party, then it's a problem.
Well, up to 161 and 162.
161.
I was indicating.
Yeah,
The two decisions operate on different planes.
yes, that's correct. They do, Malaj. But the facts, but they must be there for them to operate. I'm reading it with, I have marked it, Malaj. I myself marked it. I marked it in yellow here, Malaj, because I knew I will read it. Now I'll read that, Malaj. At this stage, a question may arise as to whether the decision of the ECI under the symbols order must be consistent with the decision of the speaker under the 10th schedule. The answer is no, and I agree. I agree, Malaj. The question is, what are the basis of that decision? Of course, they can be different.
That is the reasoning which made with the bench to allow the proceedings to proceed, Simon.
But try it. But let's see what. Of course, it can proceed. But nobody knew that they would not decide the disqualification. we must, Malas, know the reality. Nobody knew.
Dragging of the feet.
Yes, yes. Reply in 23. And then deciding it on the basis of legislative majority. So what it makes Malas. That's why ultimately Malas, institutional integrity is the heart of democratic way of functioning. Absence of institutional integrity destroys the very foundations of democracy. This is the problem. Commission.
Eloquently quotes of institutional integrity.
It does, yes.
Quoting Dr. Ambedkar.
Then Kyoto Hollehorn repeats it. And they said this is a constitutional sin. That's what Kyoto says. Defection is a constitutional sin, Malad. Now it's a badge of honor, not a sin anymore. The decision.
Paragraph 92 of the Symbols Order.
Yes, absolutely. Of the Symbols Order.
Dr. Ambedkar saying that howsoever good a constitution may be, it is sure to turn out bad.
That's
because those who are called to work it happen to be a bad one.
In fact, we are relying upon it, sir. In
And
fact,
What's the point of relying when the authorities don't? You may rely, but the authorities don't.
that's what is our case.
That's our case, Manas.
That's why I said paragraph 92 actually voices your concern.
Sorry?
163 is what you are trying.
Yes, I will just, yes. Then, Malas, the decision of ECI has prospective effect. Now, first of all, let's finish that. The answer is no. This is because the decision of the speaker and the decision of ECI are each based on different considerations. Correct. I have no dispute with that.
ultimately you also need to respond that originally your party constitution was completely based upon democratic principle. And then you suddenly brought an amendment and creating complete one-man show.
We didn't, Malas. I'll show that to your lordship. I'll demonstrate that. But Malas, the question is, this is not the remit of the commission.
When we talk of democratic principles in different institutions, governing the democratic values and the ideas, then question would arise that, well, as a political party, are you also not supposed to adapt to those principles?
I appreciate, Malas, the question is, there are institutions that perform a constitutional function. There are institutions that perform a political function. I think the level of, what should I say, integrity is much higher when you're performing a constitutional function. Whereas a political function can be rectified, but a decision made by a commission, seldom, in circumstances, can never be rectified. And this is what happens, for example, somebody could have said, you please change your constitution. We know of several cases where organizational elections are not held for years. Major political parties. Has anybody said it's done democratic and therefore I will take action and I will not recognize your constitution?
That is the line of reasonings on which the 2018 amended constitution is not relied by the election commission.
But that they can't do, Malas. How can they get into this in a paragraph 15 order?
Demonstrate that before us.
I'm sorry, Malas?
You demonstrate that proposition.
Yes, Malas. It says for No, Malas, I'm sorry, Malas. First of all, why do you say the 2018 constitution is undemocratic?
See paragraph 95 of the Symbols Order, impugned order.
Yeah, sure. 95.
That's the conclusion on the party constitution.
Page 503.
Page 503, Malas.
Yes.
Of the convenience.
That's why they say we'll go to the test of majority.
But that's the question. He's got the, if both parties have,
Mr. Sipal, we want you
PDF
to
511.
see 95 because we want you to respond as to the.
I will respond immediately. The above facts give traction. The above facts give traction to our previously noted concerns of the surreptitious nature in terms of non-communication of amendment, and equally importantly, the process of amendment in the constitution of the party not being in accordance with the conditions as communicated by the Election Commission of India dated 1910-89 to Shiv Sena inter alia, stipulating in para 2 the statutory requirement under 29A. Further, this is not in sync with clause such and such of the guidelines prescribed in exercise of the powers conferred by 324 and section 29A. In view of the aforesaid, the test of party will not come in at the aid of this commission in deciding the present case.
Now you deconstruct this paragraph.
Yeah,
Deconstruct this paragraph. There are 3 grounds on which
correct.
the party constitution is not relied upon.
Yes,
A, non-communication.
yes,
B, not being in accordance with the communication made by the
Right.
ECI,
right,
its letter dated 1910-89, and being in breach of paragraph 2 of the guidelines
right,
prescribed by ECI.
right.
And show us whether it's factually incorrect
Yes.
or it's legally untenable.
Both. I will show both. I will show both. Both factually incorrect and legally untenable.
This is the summum bonum of your argument.
Yes, I will show it both factually and legally untenable. I'll show that. But first of all, let's give this power to the commission. We've had enough powers with the commission. Let's give them another power and see the consequences of it.
We want to test.
Well, let's test it. But let's give this power to the commission that at a given point in time, they can say your constitution is unconstitutional. We will not deal with it. We will not look at it. See the consequences of that and the politics of this.
Your question will become then the entire party has to be derecognized.
Correct, to do it. Well, send me a notice that I'll read it. I will de-recognize you. You send me a notice. Please send me a notice. That's not.
The notice, Mr. Sibal. See the second ground. Second ground is 89. When Bala Sahab Thackeray, leader, was there, a notice was given.
Yes,
Now, what
he
you
corrected
say
it.
is, after that, you
He
have
corrected it.
created an amended constitution, but both of you claim there is an amended constitution.
No, not only that, he got benefit. He became a legislator because of that constitution.
Your affidavit
Well, let's kindly see. You take the benefit of it, and then you say, now you'll not look at it. This is the argument. You became a legislator, you became a minister, you got a ticket from the party, you became a member of the Karani, and then you say, look, don't look at it.
It will not be the question of that your interest is conducted. The question will be the legality of the order of the commission.
Exactly.
No, Malaj, I'm sorry. This court has said, if there are two people who claim under the constitution, you can't go behind it. There's a judgment of this court.
My lord, also, my lord, just apropos what has fallen from your lordships, Election Commission, my lord, there are 5 judgments of the Election Commission.
Cannot go to the constitution.
Yes.
And number 2, my lords, where the other party
Has got the
also relies upon so-called undemocratic constitution.
You can't go behind.
Then, my lords, Election Commission has said we can't get into the dispute, and we will go by what is there on the record.
Mr. Sibal, Mr. Kamath, we pointed out this paragraph
Yes,
for
Madam.
you to respond.
Murad, this paragraph is an act of genius to ensure that you don't look at the organizational structure. That's my answer to it as far as the reality is concerned. It's an area of
more forensic approach.
Murad, I'm sorry to say, we sit here not realizing the realities of what happens on the ground. And Murad, if we allow these realities to continue and give this part of the commission, the consequences will be very grave. That's all I can say. But I'll answer that question in any case.
माननीय सुप्रीम कोर्ट में शिवसेना विवाद की ये बहस अब एक बेहद निर्णायक मोड़ पर पहुंच चुकी है। वरिष्ठ वकील कपिल सिब्बल ने अदालत के सामने जो तीखे सवाल उठाए वे सिर्फ एक पार्टी के नहीं बल्कि हमारे देश के लोकतंत्र और संसदीय नियमों के भविष्य से जुड़े हुए हैं। अब देखना यह होगा कि माननीय सुप्रीम कोर्ट इन दलीलों पर क्या रुख अपनाता है और आने वाले दिनों में शिंदे गुट इस पर क्या जवाब देता है। दोस्तों, इस कानूनी बहस पर आपकी कीमती राय क्या है? कमेंट्स बॉक्स में जरूर साझा करिए। जय हिंद दोस्तों।